Josh is an associate professor of law at the South Texas College of Law in Houston, who specializes in constitutional law, the United States Supreme Court, and the intersection of law and technology. He is the author of the critically acclaimed Unprecedented for Constitutional Challenge to Obamacare and Unraveled, Obamacare, Religious Liberty, and Executive Power. He was selected by Forbes magazine for the 30 under 30 in law and policy, and has twice testified before the House Judiciary Committee. He's an adjunct scholar at the Cato Institute and the founder of Fantasy SCOTUS, the Internet's premier Supreme Court fantasy league. He's a prolific blogger at joshblackman.com, and most importantly, he is also a great Twitter follower. And now here's Matt.
At Josh M. Blackman.
Here's Matt to introduce the philosopher.
All right, thanks again, guys. I'm Matt. I wrote the Immigrant and Refugee Project. We just want to thank you for coming out, and I'm actually going to let Kevin and Hila introduce themselves. They are immigration attorneys who work in Raleigh.
Hi, everybody. My name is Hila Moss. I am a staff attorney at the U.S. Committee for Refugees and Immigrants in our North Carolina field office. I have been practicing immigration law exclusively for 4 years after graduating from Campbell in 2013. And I have worked in the nonprofit sector for the last 4 years as well, and I'll be about 2 years with USCRI in November. I work with an unaccompanied minor program where we helped exclusively pro bono children, unaccompanied minors that came to the United States looking for a safeguard here. And then we also do a low bono fee-for-service program for immigrants and refugees.
And I'm Kevin Schroeder, also staff attorney at USCRI in Raleigh. Also 2013 graduate of UNC, and have been with USCRI for about 2.5 years. Just a little bit about our organization as well. We're one of the 9 voluntary agencies that work with the government to resettle refugees in the United States. So we provide a whole host of services, reception and placement, picking up refugees at the airport, helping them find their first apartment, helping them find their first job, providing job training and placement for a period of about 5 years, as well as our program that provides services to help them apply for residency and citizenship, as well as family reunification. So that's a little bit of our perspective.
I think that's my cue. Hi, everyone. I'm Josh Blackman. I am very grateful to talk today about the Supreme Court's upcoming case concerning the constitutionality of President Trump's travel ban. But before I get to the case, I'd like to discuss another case which you may have studied in constitutional law, Texas versus Johnson. This case considered whether a person could be arrested for burning an American flag at a political protest. The decision broke down on a 5-4 line, but to the surprise of many, the deciding vote was cast by Justice Scalia in favor of the flag burner. Now, Scalia was no fan of flag burners. He once said, and this is a quote, "If it were up to me, I would put in jail every sandal-wearing, scruffy-bearded weirdo who burns the American flag." Scalia said, though, "I am not king." Indeed, Scalia felt the answer was compelled by the First Amendment, even though he disagreed with the result. I often tell my students that Texas versus Johnson is a good gut check for lawyers. If your understanding of constitutional law overlaps entirely with your own philosophical beliefs, you may want to reassess the former. That is much how I feel about the travel ban. I'm a libertarian and generally favor open immigration policies. I think the idea of banning the entry of aliens from certain nations merely because those countries have been associated with terrorism is an awful policy. I agree that the executive orders will cause horrible hardships to families, refugees, and those seeking a better life. And I'm very grateful for the work that lawyers like Kevin and Hila do. I'm also doubtful this policy will do much to improve our national security. Yet, I put my cards on the table. I'm firmly convinced that Congress gave the president the power to take these actions. And I'm also firmly convinced that the Constitution does not bar him from exercising the powers in the manner in which he did. So my talk will be in 5 parts. First, I want to provide a brief history of the travel ban, including some statements that candidate Trump and now President Trump made about the policy. Second, I want to discuss the contents of the 2 executive orders, both of which have been halted by the courts. I have actually not filed an amicus brief in this case. I'm the only professor in the world who hasn't. But I don't like supporting policies that I think are bad, generally speaking. And third, I will discuss whether Congress has afforded the president the authority to take these actions from a separation of powers perspective. Fourth, I'll get to the First Amendment, specifically the Establishment Clause, and probably during Q&A, I will give you a preview of the arguments on October 10th, next month, for the Supreme Court. So our story really begins long before Donald Trump, President Trump, was even a glimmer in our eyes. In December of 2015, then candidate Trump called for, quote, a total and complete shutdown of Muslims entering the United States until our country's representatives can figure out what is going on. That was the quote. Over the next few months, Trump said he would shift his position from Muslim ban to extreme vetting and banning people from certain territories, as he called it. Or did he? During an interview on 60 Minutes in July of 2016, Trump told Leslie Stahl, you can still call it whatever you want. We'll call it territories, okay. Was that a repudiation or a wink and a nod to the alt-right? But a week later on Meet the Press, Trump seemed to again repudiate the policy, telling Chuck Todd, I'm talking territory instead of Muslim. Now that's not a complete sentence, but we can maybe parse what he's trying to say there. Alas, the burden of reconciling these statements has shifted from fact checkers to the federal courts. And a number of courts have cited these interviews and these statements to say that Trump's 2017 travel ban is connected with his statements made before the election. And indeed, they've thrown into this pile statements made by Rudy Giuliani and other surrogates of the president, right? So that is the basic frame of how the courts have constructed this argument that the president has an animus towards Muslims and that his policy of the travel ban is tainted by these statements which were made some time ago. All right, now let's fast forward till after the election. January 27th, feels like a lifetime ago, doesn't it? January 27th, I'll never forget, it was a Friday. I was out at dinner, and the president issues his executive order, and it sent shockwaves to our system. I'll give you a rough cut of the order. For 90 days, certain aliens from Iraq, Iran, Libya, Somalia, Sudan, Syria, and Yemen who were deemed detrimental, that's the word of the statute, to American interests will be denied entry. And then for 120 days, the refugee admission program will be suspended. I'm not going to talk much about refugees. I think my colleagues will give a lot more. I'll focus on the travel ban for the aliens. Almost immediately after the order was signed, chaos. Right, it was absolute chaos. Airport officials began detaining nationals from those nations. And what I've called the airport cases, we had situations where judges ordered the release of these refugees. Now think about it. When you got on a plane, let's say you were in, London Heathrow, right, or De Gaulle coming in from Syria or whatever. When you got on the plane, your papers were good. Everything was fine, right? But as you were crossing the Atlantic or Pacific or whatever it was, that's when the policy was issued. So judges issued these emergency habeas orders, which were very hectic. Within, I think, a span of 2 or 3 days, more or less everyone was let out of the detention cells at the airports. By the way, when you are at a U.S. airport at the checkpoint, you're not on U.S. soil yet. Until you actually clear customs, you're actually still in this weird nether region. But in any event, the courts ultimately enjoined that first policy. There was a lawsuit brought by Washington. The Ninth Circuit affirmed it. Government did not go to the Supreme Court. They tried again. On March 6, 2017, President Trump issued a second executive order that superseded the first order. Couple changes. It removed Iraq from the list. It also made clear that lawful permanent residents, that is green card holders, right, were not subject to the ban. That was always a mistake. They should have never denied entry to the green card holders. I think that was a big screw up, the first one. But rather than quantifying whether aliens from these countries had engaged in terrorist attacks, which was always, I think, the wrong question, they now said that the U.S. lacks sufficient diplomatic relations with these 6 nations to trust their screening mechanisms. For example, they said Iran and Syria do not cooperate with U.S. counterterrorism efforts. So the idea was, it's not that these people are necessarily dangerous, but we can't rely on their governments to verify the documents that they are who they say they are. This policy, too, was challenged in court, and injunctions were issued by judges in Maryland, by judges in Hawaii, and any other judge that could jump on the bandwagon quickly enough. That case came up to the Supreme Court. I don't want to get into the nuances. There was some stays, interventions, it's madness. Bottom line is, The policy, as it stands right now on September 11, 2017, is that it's almost entirely enjoined. There's a small group of perhaps distant relatives and perhaps an even small group of refugees at the moment who are subject to the ban, but the ban doesn't have much teeth at this moment. Next month, the court will hear arguments in the merits of the case. That's what I want to focus on. I don't want to bother you with the interim orders, which are confusing as heck. So the first question we always have to ask is, does the president have the power to do this? I'm not going to talk about Article 2. I do think there's actually a decent inherent argument that the president can deny entry to those he deems dangerous. I'm not going to make the argument here, though. I think there is. So let's focus on statutory authorization. 8 U.S.C. 1182F. Let me read it to you. It says, whenever the president finds that the entry of any alien or any class of aliens into the United States would be detrimental to the interests of the United States, he may, by proclamation and for such periods as he shall deem necessary, suspend the entry of all aliens or any class of aliens, as immigrants or non-immigrants, or impose on the entry of aliens any restrictions he may deem to be appropriate. In terms of delegations of authority from the Congress to the president, that's a pretty broad one, right? He can deny entry to any class of aliens he deems detrimental to the interest of the United States. And this term entry, is a somewhat quirky term of art because it's not a word used in our current immigration law. We don't have entry anymore. That's an older vestige, it's an older statute. Usually we think of a person entering as having a visa, right? And there's another provision of law that says that the government can't impose nationality-based restrictions on the issuance of visas. Actually, it doesn't say religious-based distinctions, right? There's nothing in the statute barring you from denying someone a visa because they're Christian or Muslim, which is, I'll get back to that later. But there is a statute that says you can't use nationality when restricting access to visas. So one of the first statutory questions, right, is this. How do these two statutes reconcile? I've argued since the outset of this litigation that entry is a concept separate from visas, that you can have a valid visa and still be denied entry. I'll give you a very good example. Let's say you show up at JFK Airport in New York with a valid visa and you have Ebola. You're not coming to the United States. Let's say you show up at the airport with a valid visa and the agent starts asking you questions and he finds out you lied. And maybe you gave some false information, maybe your story doesn't check out. They can detain you and turn you back around. And by the way, at the airport, there's no judge, there's no jury. You get sent right back. They literally put you on a plane and send you home, or wherever you came from, as it were. So in my position, that these statutes are not in conflict. The plaintiffs have argued that this later in time statute, which passed in the 60s, actually supersedes in a way or amends the earlier in time statute such that the government can't deny entry based on nationality. I think there are a lot of good reasons to reject that. You have a very clear delegation of authority. Moreover, if you do take that construction, you start veering into the Article 2 argument that Congress is constraining the president's foreign policy powers. I would avoid that. So I think there's a very good statutory argument the president has his power. But that's not what you're here to do. Right? You guys don't care about statutes, right? You care about the Constitution. That's why you got the Chick-fil-A. So let's talk about the Constitution for a few minutes. Early on, there was a due process argument. That has somewhat faded away. The argument here is really about the Establishment Clause of the First Amendment. Now, we all know about the First Amendment. The Establishment Clause usually arises in the context of, can a city put up a creche, right, or a Christmas tree? Or can you have a Ten Commandments monument in a park or something like that, right? This is a slightly different flavor of the Establishment Clause. The argument here is not that the president is trying to promote one religion, but that he's disfavoring others. And in particular, he's disfavoring Muslims. And as proof of this disfavor, this disapprobation, the plaintiffs cite the statements I made before, the total and complete shutdown of Muslim immigration, right? The 60 Minutes interview, all these things, right? And Rudy Giuliani, and they make this tapestry to show that Donald Trump in his heart of heart hates Muslims. And because he hates Muslims, the policy is tainted, right, by this animus. And as a result, it violates the Establishment Clause. really, this isn't really an establishment clause argument. Maybe it's a free exercise clause, or maybe even a due process argument that it lacks any rationality because it's motivated by animus. I think actually the establishment clause is not even a good fit for the argument, but that's where courts have stuck it. I think it would be much better as a due process or establishment or equal protection, perhaps. But that's the argument that's being made. I think there are a couple problems with this argument. First off, let's separate the statements. You have inauguration before, inauguration after. There's zero precedent to the fact that you can cite statements by a private candidate when dealing with the president's actions. When the president takes an oath, he assumes a new responsibility. Whether you think Trump actually did that, we can talk about maybe later, but at least under a presumption of regularity, when the president steps into office and takes the oath, there's like almost like a baptism, a cleansing, if you will. Not much of a cleansing here, maybe, but in theory, there's a cleansing of the soul, so to speak. So I think it's problematic to look to the statements before the inauguration. The statements after the inauguration, and I mean this with sincerity, are frankly ambiguous. The way that President Trump speaks is not always very clear what he's talking about. His use of pronouns is confusing as hell. Because you ever know what it is, that is, I don't know what he's talking about. And I don't think courts should be in the business of trying to parse these ambiguous statements. Further, the president has given what I think are not persuasive, but rational national security justifications for why he did it. I think that rebuts it. But there's another reason why it's, I think, dangerous to start applying domestic establishment clause case law to foreign policy decisions, and it's this. Much of our immigration law is premised on religion, right? We know about the Lemon test, right? We can't have religion and say intertwined. Take a look at immigration law and look how intertwined religion is, right? Asylum law often requires immigration judges making very tough calls about a person's faith and their doctrine and how closely they adhere to it, right? And what are the tenets? And that sort of thing would never fly in an American court, but we do it all the time. I'll give a few other examples. There are special categories of visas for preachers, for pastors, right? That if you're a pastor, you get a jump and you can get a visa much quicker than anyone else. If that was a domestic statute, that would not fly. Give me another example. We actually have a statute in the books that applies to the Soviet Union called the Lautenberg Amendments that said if you're a Jewish person or an evangelical Christian, you get priority. You get preferences for issuing of visas. Can you imagine a domestic statute that looks like that? The ACLU will be out in 5 minutes, right? So I think it's a good reason why that 1960 statute didn't mention religion in the categories of protected classes. Because Congress recognized that much of our immigration law, much of our asylum law, much of our refugee law has religion at its core. So there hasn't yet been this extension of our First Amendment case law to the context of immigration. I think there's good reason not to. Which is why I think these cases are really due process cases. What they're basically arguing is that the president lacks a rational basis to act. It's infected by animus, like in the Romer case. And I'll give you proof of this. Last week, the California Attorney General, the New York Attorney General, and those attorneys general sued President Trump over rescinding DACA. This is a deferred action policy from President Obama. And even though there's no establishment clause precedent in this complaint, it's indistinguishable from the travel ban. They argue that President Trump's statements about Mexicans and Latinos shows he has animus towards Mexican Latinos. And the reason why he rescinded DACA, which generally affects Mexicans and Latinos, is because he hates them, right? They cited his statement that the murderers and rapists, you remember this one, right? The murderers and rapists, right? And we need to go pardon Joe Arpaio, and we need to build a 55 million foot wall, whatever else it was, right? The travel ban case is indistinguishable from the DACA case, even though the establishment clause is not relevant. So at bottom, I don't see this as an establishment clause case. I think this is really a due process case. Which is why, and I make this point very generally, the Supreme Court should be very careful what it does here. Because if you start opening up the president to liability based on statements he made in broad context, right, courts can start doing a lot of things they're not used to. So let's say that the courts find that indeed President Trump bears animus towards Mexicans and Latinos, right? Let's just say that's the holding of the case. President Trump tries to rescind NAFTA, exit from NAFTA. Could a court actually issue an injunction saying that his decision to exit NAFTA is based on hatred towards Mexican workers and how they're robbing the Americans? Let's say President Trump defunds Planned Parenthood, right? and someone sues, and they include all the allegations of the things he said to women in the beauty pageants and how he told Billy Bush he wants to grab women, right? And that shows his animus towards women, right? Could a judge halt the defunding of Planned Parenthood, find that the real reason he's doing this is because Trump hates women? I'm very uncomfortable with these sorts of rulings. You may like it in the travel ban context, you may even like it in the DACA context, hell, maybe you like it in the Planned Parenthood context, I don't know. But this sort of extrajudicial fact-checking, I think becomes extremely problematic and could really hobble presidency. Now, if you say, I want to hobble the presidency, I appreciate your candor, but that's not what the court's here, that's what we have elections for. I want to now give a brief preview of the Supreme Court's oral arguments, which are coming up in, just about a month. I will be there for the arguments. The Supreme Court has had a number of interim orders concerning stays in the Ninth Circuit and these emergency appeals, but a lingering issue, is this case still live? The original travel ban, way back in January, said we need 90 days to figure out what's going on, and 120 days for refugees. We're like 8 months later. Okay, so there was a second travel ban, we need 90 days again. Okay, so the question is this: when did that 90 days start tick, 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 right? When did the 90 days start ticking? Did it tick at the Supreme Court's last injunction? Or has it never started ticking? Because as I mentioned, the policy has never been allowed to go into effect in its entirety. Never. There's a small category that are subject to it, but most people, grandma, whatever, they can get in under the current orders. So the government may actually argue to the court that they've not had their 90 days, which would mean the case doesn't become moot, right? Otherwise, I think it's moot in a couple weeks. Alternatively, the government may just want to let this case moot out, vacate the lower court decision, dismiss this policy, and move on with their lives without having a negative Supreme Court decision. By the way, when a case becomes moot on appeal, the Ninth Circuit decision gets vacated, so it's no precedent. So there may be an advantage to the government simply saying, okay, let's let this run this course, let's not rush this, and we'll just let it moot and go away, and then we'll go back to building a wall, whatever else you want to do, right? Defending DACA. The court, though, may not be so inclined, and I don't think the plaintiffs want to admit it quite yet, but I think they want a ruling here. There's something called the voluntary cessation doctrine, and if you study civil rights law, you know what that means. Under the voluntary cessation doctrine, if a government actor says to the court, hey, dismiss the case, we're going to stop breaking the law, right? Often the judge will say, I don't believe you, right? Let's say there's a police department with a practice of brutality, and they always beat people up. And the sheriff says, Your Honor, we're going to stop this tomorrow. Dismiss the case. The judge will often say, give me a break, right? Just because you're saying you're going to voluntarily cease this unlawful conduct, prove it. And they'll maintain jurisdiction to see what the deal is. It's entirely conceivable that the plaintiffs can argue, Your Honor, we don't believe they're actually going to do this. Keep the case. And so jurisdiction may not be lost. I don't know what the justices want to do. What I do know that is in two decisions, the justices have slightly pushed back on the lower courts. Not a lot, but they pushed back. And they said, you guys have gone too far. So at a minimum, it's unlikely Trump has a victory, but it may not be a complete loss either. What happens? I have no idea. I will now gladly turn to my good colleagues who actually do immigration law. I simply talk that. So thank you so much.
Thank you very much, Josh. And I'm going to turn it over to Hila and Kevin. But first thing I want to note is while I was sitting here, I actually got a Politico alert that is timely, and you guys may talk about it.
Did they appeal to the Supreme Court?
Well, so Trump today, his administration asked the Supreme Court to allow authorities to keep up the block on many refugees covered by the ban, but, quote, threw in the towel for now on efforts insisting that grandparents, aunts, uncles, and cousins should be covered. So that may play into your comments.
Breaking news.
Yeah, breaking news.
You heard it here first, folks.
That happened while I was sitting here. And Josh,
I'm glad you're paying attention.
Yeah.
The professor, no, I know people looking at their phones. People don't look at their laps that much. That's not how things. That's how people study.
And you mentioned the chaos that followed immediately from the travel ban, and that's where we're going to lead in to Hila and Kevin as practitioners. You can take it and talk from here about what it was like as practitioners immediately after the travel ban went into effect, and then what it's been like since.
Great, yeah, so, chaos is the right word. In the days, and even up to now, following the travel ban, there have been effects that have directly affected a number of our clients in very individual ways, and then sort of overarching broad strokes that have affected the community of refugees in the Triangle, and immigrants more broadly. One of the biggest things we've been dealing with is fear, especially in the refugee communities. Well, from my perspective, Hila will talk a little bit more about immigrant communities. But fear in the refugee communities that somehow the agreement by which they're here is no longer on the table. That if this can be taken away, the rest of it can be taken away. And there's, that's outside of any legal argument, that's outside of those sorts of considerations, but that's a real thing that's affecting the community and a real problem for the people that we've brought in as refugees. There's also a lack of trust in, as I was saying, in the current policy. So people, like I said, feel like if one thing can be taken away, what's protecting us from being from having the rug pulled out from under us in a lot of different ways. There's also been a number of real effects on individuals. So especially in family reunification cases, we have had enormous delays in the processing of those cases for people who desperately need their family members here in the United States. And even though the ban has been rescinded, that ripple has sort of continued to flow through the entire process, causing delays in security checks and delays in all sorts of steps of that process that bring someone here. I'll give you a couple of examples. We had an Iraqi mom who had applied for family reunification for her son, who had actually turned 21 but was under 21 at the time when she arrived, so she was able to file an I-730 family reunification petition to bring him here after the fact. The reason he didn't come with her was because when they were fleeing violence from ISIS, she and her middle school age daughter were able to go one place and he went to Turkey, so he was in a separate place, separate refugee process. That I-730 was approved the day before the first travel ban went into place. So she had 2 separate meetings with her. The first, jubilant, extremely happy that her son was finally going to be here. She had been here for close to a year at that point. She's pretty severely disabled. She's able to walk, but very slowly with a walker. She's not able to work. She has arthritis, osteoporosis, a couple of other medical issues. And of course, it's just her and her young daughter here. So she had been waiting, relying on friends and family for months to pay her rent and to get by. And that, essentially, the process of moving forward and on the consular side with that approved I-730. So USCIS had made the determination there is a family relationship here, we can move forward, you can go to the embassy, have your interview, we'll do security checks and bring you to the United States to reunify with your mom. That all stopped. Once it stopped, it took it a long, long time to get restarted. So he's actually still not here months later and won't be for the foreseeable future. And she, obviously that has huge effects on her life, on her sister's life. He's the only person in the family who can really provide for them and work and do all of that. We have another family, an Afghan mother and father, and one of their children, their 3-year-old daughter, was separated from them when they were fleeing violence in Afghanistan. They went to Pakistan. They were able to get the daughter, I actually can't remember where she is, but they were able to get the daughter to live with the maternal grandmother because they thought that she'd be safer there. Because the family was still worried about the possibility of them being tracked down in Quetta, Pakistan, where they were moving to. And they wanted their daughter to be as safe as possible. Again, the refugee processes are separate, but their understanding, and they were told this by UNHCR and by the different organizations that they work with along the way, that they would be able to bring their daughter as soon as they arrived, and they would be able to apply to bring their daughter, and that of course has been significantly delayed as well. They're still waiting for their daughter to arrive, and of course at this point the daughter's been separated from them for half her life, barely remembers her father or mother. So those are just the individual impacts that have been caused by this travel ban to our refugee clients. I know that on the immigrant side as well, we've been having a number of pretty serious effects to our clients, both broad and individualized.
Right, and just to piggyback on Kevin too, so USCRI has been resettling refugees for 160 years. We have 8 field offices in the United States. We have 1 in El Salvador. We're working on opening 1 in Honduras. And USCRI is very well known for doing the refugee resettlement. And with that, we have our own staff, our own internal staff that actually suffered from the travel ban. Certain employees had to be let go because we weren't getting the funding. And the way it works is that with an agreement with the State Department, we resettle refugees and we receive a certain amount of reimbursement for doing so, because a lot goes into finding housing, finding a car, finding furniture, finding jobs for them, because they don't get a free ride here. They may come in and get a little leg to stand on, but then they're on their own. We only, work with them about 30 to 90 days, maybe a little bit more depending on what needs they have. But with the programs that we have in our office, we're seeing a big hit just emotionally with us too. A lot of our colleagues, it's been a sad year. These last 8 months have been really rough, just because the reason why we're working at USCRI is not for the big bucks, because they're not there. We're here because we want to help people, and that's all we care about. And when you can't, and when there's just nothing but fear and turmoil affecting our clients, it reflects on us. And so I know our organization is really suffering as well, just emotionally, mentally, because we can't help these people. And then our colleagues are losing their jobs because there's not enough refugees to bring in. I mean, going from 110,000 a year to 50 has really hurt USCRI, as well as the other VOLAGs that are in this.
What's VOLAG? Tell me what VOLAG is.
Sorry, VOLAG is the
Voluntary agency.
Sorry, Professor.
Yeah.
voluntary agency that resettles. So we're one of 9 VOLAGs. Lutheran Services is one of them. Catholic Charities. They're all. We have 8, 9 throughout North Carolina.
I think all 9 are represented in North Carolina.
Yeah,
right?
8 plus us, 9 in North Carolina. And then there's a bunch throughout the country. But just USCRI in general, since October of 2010, since the fiscal year of 2010, we've resettled 50,000 individuals. Everybody gets a percentage of who they get to resettle. So we've settled 50,000, and then we resettled 11,000 in ending September 30th, 2016. So in fiscal year of 2016, we were able to do that. But we have a really great history of doing that, and we also work with a lot of partner agencies and network agencies to get that effectuated. So we have the refugee side that's hurting. Then we also have the immigrant side, which I'm more familiar with, Kevin and I are more familiar with, because we do the legal side for them. Refugees, when they come in, they already get status. They come in with refugee status, they maintain it for a year. After 1 year of physical presence in the United States, they can apply for their green card. It's a pretty simple process, and even while they're here during that 1 year interim, they get work authorization, social security number, driver's license, and then our colleagues work with them on kind of assimilating them into the workplace and just living in this life in general. We have clients that have never seen a working toilet before, so we have to really teach them and assimilate them into our practices. And so we also have a lot of fear in our immigrant clients, with our immigrant community, and that's just because they've been here for years and they're feeling like outsiders. I mean, as Josh mentioned, even with the candidacy, candidate Trump, it was vitriol, it was hate, it was animus towards these people, and everybody's a criminal and a rapist, and we have a lot of clients that are just scared. They're absolutely terrified. They either don't want to proceed with the legal case because they don't want to put their name into the system, because then they're afraid that that's going to hurt them. And there really is 2 sets of people. One group of people that immigration knows who you are, they know that you've had an application filed for you, that you used to live at this address or maybe still live at this address. And then there are those who've never been caught at the border, never been caught in the United States, never been arrested for anything, so they don't know about them. But so we deal with these 2 sets of groups all the time, and we have to kind of lay it all out there, and we have to tell them, yes, we can proceed with this legal case. There's always going to be a chance. We cannot 100% guarantee anybody's safety here, which is difficult, very difficult to have to tell a mother and her children that I can't 100% guarantee your safety. But we can do this legal process that can get you something, and it's better than hiding in the shadows. Before, with Obama was not immigrant friendly by any means, but he did have some policies that helped kind of bring these people to the forefront, but it was only temporary. DACA is temporary, and it's always meant to be temporary. The idea was that DACA would go in place, and then Congress was given the ball to do something with it, and to make these kids count, and to give them, their lives here accreditation. So we were waiting on Congress to do something, and DACA was 5 years ago, in 2012. So obviously since then nothing's really happened, but we're trying to take people out of the shadows and give them a life here where they're not afraid to drive, they're not afraid to walk on the sidewalk looking Hispanic. And we have really great organizations here in North Carolina that are helping people get on the right path, or at least, stay active with the community to maybe help bring some kind of really positive, significant change for our clients. But we do see a lot of fear, and I particularly work with children, anywhere from a few months old to 18 years old, and the fear that you see in their eyes, they don't understand this, they just see their mom crying, or their parents upset. So it's been a rough year for our organization, and all VOLAG, refugee resettlement agencies, it's been rough just having to know that there's only so much you can do for these people, and you lay it on the line, you give them their options, and they say, but Abogada, please tell me what to do, please, 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 and you don't know, you can't. The humanity kind of rips you apart sometimes.
Yeah, and I think that's the best, really the perspective that we can provide as practitioners is when we're talking about these issues, we so often, it's easy to forget that you're talking about people and you're talking about their lives. Cutting the number from 110,000 to 50,000, from a practical standpoint, that means that people who've been living in a refugee camp in Uganda for 20 years may stay there for 30. Kids who have never lived in their home country but are refugees from their home country because of violence are waiting to start a life. We have clients all the time, refugee clients who are in their teens, their 20s, who don't remember their country. They were chased out in the late 90s and have nowhere to go to. They've never had a job. They've had very limited formal education because there's really been no means for them to achieve that. And when they come here to the United States, they only need the one chance because they take it so emphatically and successfully. It's really a fantastic thing to watch.
Do you actually have numbers on how many of the refugees after they get their green cards, like go to college, like actually like, do we have what's your sense of that?
100%.
No,
I don't know.
I don't know the exact numbers on it. I could, just speaking from experience with our organization, the second generation, the first generation,
Got it,
they're arriving
Right.
here.
Okay.
They're arriving here as children. They tend to be very successful in their schooling. They tend to seek out good jobs. They take advantage of the job training programs that our office provides. They obviously learn English incredibly quickly. While the first generation is typically working hard, but have a pretty insular life because their goal from the start was to just find safety and stability for their family. So they have that, they work hard, and they just continue on with their lives in that way. But on the travel ban side as well, even not with just refugees being resettled, cutting the number, on the travel ban side, even with the ban as it could remain in place, you're talking about people who can't get a B2 visa to come to their child's wedding. You're talking about all of these real effects that happen to people who have absolutely nothing on their record to suggest that they have even the most minute connection with any sort of terrorist organization, any criminality, that are being stopped from entering without much justification at all, if any. When you talk about doing a blanket refusal to issue visas from people from a certain country, it's difficult to find any justification to do that, it's difficult to find any way that gets to limiting terrorism, limiting criminality, when you can't really demonstrate any individualized finding on that person that they have even the slightest hint in their record other than the country that they're from to suggest that they could be involved in something like that. So I just wanted to impart the perspective that we are talking about individual people when we talk about these things. And so another thing that we've been doing recently, really since January, is trying to step up our community outreach in the Triangle, going to the apartments where our clients live, providing information about their rights and their options, because as we were saying in the beginning, one of the things that we've had to work hardest against is the fear and the rumor mill that circulates in communities. A lot of misinformation gets passed from person to person. one of the silver linings of all that's been happening is there's been a huge public outpouring of support, a lot of volunteers, a lot of people interested in assisting. But even that's sort of a double-edged sword, because as I was saying, none of our clients want to be public figures. They don't want the attention. They don't want people coming up to them all the time and saying, "Oh, like, how can I help you?" Things like that. They just want safety. They want some semblance of calm for maybe the first time in their entire lives. So that's difficult for a lot of people as well, and we've had clients struggle with that also.
Right, absolutely. And just to, so Kevin said B2, visitor visa.
Right, I'm sorry.
He hasn't taken immigration yet. That's just a visitor visa to come in, but it affects everybody. We're having a really difficult time trying to allay the fears. There's a perpetual, persistence of these fears, and well, my cousin said this, or my friend said this, and that's what we're really combating here. But at this point we can open it up to questions if anybody, because there's a lot we could talk about, but I'd really like to hone in on what exactly you guys have questions about. So please feel free to
Questions?
raise hands. Yes, ma'am.
So thank you all for being here today. My question relates to the travel ban and the legal arguments behind it regarding the Establishment Clause. So you mentioned that you saw it more as a due process clause inquiry. Why would you separate that? Because I suppose my understanding was that in the Fourth Circuit, at least, when they mentioned the Establishment Clause, they did it after an inquiry of the Mandel test, which was, it's a facially legitimate and bona fide requirement for whatever executive order is issued. Like the travel ban, they found that it was not a rational inquiry, just a rational inquiry, but also one done in good faith. And then they went ahead and analogized that to a constitutional inquiry on the Establishment Clause to see if it was secular or if in good faith they could establish that it wasn't.
Thank you.
Could you talk a little bit more about that? Because I didn't fully understand your reasoning.
I didn't talk about it, that's why. I'd be happy to talk about Mandel. So there was a case in the 1970s where there was a Marxist professor who had sought to enter the United States. His name was Mandel. And a number of American universities, as they often do, Marxists wanted to come speak. And they applied for a visa so he could come and give lectures at various American universities. Now, Mandel had previously been to the United States, and I think he had overstayed his visa, or there was some sort of technical violation. It was nothing severe. He went home eventually. Now, the government denied his visa. And the stated reason why they denied his visa was because he had overstayed previous visas. That wasn't the reason. The reason why is because he was a Marxist, and he was a revolutionary, and the government, I think it was the Nixon administration at that point, didn't want this guy coming to the United States. So Mandel sued. The court's standing analysis was non-existent. They basically ignored standing. They said, well, he has standing to sue. And they said, well, when the government puts forward a policy that's facially legitimate and bona fide, which is the word used a moment ago, we're not going to look behind the denial of the visa. Now, you had Justice Marshall in dissent saying, guys, come on, this is insane. Let's peel back the curtain a bit. Right? Let's look at the real reason why this visa was denied. It had nothing to do with his overstays. It was because he was a Marxist. The vote was 8-1. Right? I think even Brennan went along with the majority. So the facially legitimate and bona fide test, I think, has been applied in a way inconsistent with Mandel. The way I read facially legitimate and bona fide is that facial modifies both words. And I think if you read Justice Kennedy's opinion in Kerry v. Ding, that's how it works. You look at the reason given for the denial. I'll give you another explanation. Kerry v. Ding was about the denial of a visa, not a facial constitutional challenge to an executive order. I don't think Kerry v. Ding applies at all. I think we are only reviewing this for rational basis, which is why I think it's a due process case. I think that's the only way to look at this case. And what the courts are actually saying is Trump lacks a rational basis because he's motivated by animus, rumor. Right? That's what this case is about. This Establishment Clause is a great window dressing. That's not what this case is. It's a due process case. And if you don't believe me, read the complaint in the equal protection case. Yes?
I'm sorry, just to follow up on that, it's a very long question, so sorry I didn't get it all out there. But my question rests more on, in the Fourth Circuit opinion itself, they specifically transitioned from the Mandel test to what they looked at the recent 2000s cases, right? Like Zedvitas, for example, and that was a detention case, but it specifically mentioned in the majority opinion that they would start to apply constitutional limits
Was that a person in the United States, that case, if I remember correctly?
Sorry?
That was a person in the United States?
That was a what in that?
Person being detained in the United States, in
Yes,
that
it
case?
was a detention.
So there's a very big difference between constitutional law if you're in the United States and outside. A very big difference, right? If you're here in the United States and you're not here lawfully, you get your Miranda warnings, right? You have some free speech rights, but not a lot. You generally get your criminal procedure protections. So I'm okay with applying robust First Amendment protection to people in the United States, but this is about entry of those not. So, I mean, that's another point which the government keeps extending domestic law to foreign. There's a disconnect there, but I appreciate the question, which I appreciate a lot of effort. So and I can talk afterwards, go into the details. I want to make sure we have enough time for everyone else.
Yes, sir.
Yes, thank you all for coming. I used to work in campaign politics, and I'm very uncomfortable with the idea that somebody can say something on the campaign trail, which is the basis of them getting elected, or part of the basis of them getting elected, and then they're not held accountable for it once they're in office. And, I mean, even David Duke himself would be smart enough to come up with a cover story when his real motivations are clear. I'm not saying that that's the Trump position, but that was an extreme example that seems like the argument you're making, could be applied to. I was wondering, is there any precedent for this? Is saying like a candidate said something and then you can't go back and look at what they said later on?
I think it's the opposite. There's no precedent that's ever cited campaign statements. Right?
And so,
We've had politicians for 200 years making promises they broke. No court's ever cited those statements in any context.
and legally, is there any reason you cannot go with those statements now?
So I mentioned the context of the president in particular. The oath, I think, is quite important. The inauguration is quite important, and it takes a person who is a regular citizen and makes him the president. I think there's every reason not to extend it, and very few reasons to extend it. Thank you.
Yes, sir.
I just have a question regarding extreme vetting to the whole panel, I guess. A lot of the sort of ban has been put in place specifically with this intent of coming up with these new extreme vetting processes. The ban has now been rescinded for everyone who isn't a refugee. How do you sort of balance the nature of the refugee processing system that already exists and the strength of that system going through the UNHCR, and then individual tests, it coming into the United States already as not being a form of extreme vetting? Aren't those the same thing?
You guys take that one.
Yeah, absolutely. So the ban is banning refugees who don't have a or bona fide relationship to some kind of family member. And at this point, it just got extended to aunts, uncles, cousins, nieces, nephews. And then, so those refugees are allowed to come in. And then you've got the refugees that have assurances, so documented formal assurances with refugee resettlement agencies like USCRI. So the refugees that are not allowed to come in are the ones that don't have those two things. But these refugees go through, 18 to 24 months extreme vetting processes. And I think the order, the Ninth Circuit, the order that just came out, it is, pretty relevant, and it does a really exhaustive run through of the vetting process. But I know in our opinions, when we've met, refugees that have come in through the vetting process, everything seems to line up pretty well. I mean, the stories they tell us are the stories that they told to UNHCR.
Yeah, that and the vetting process itself, to me, seems to be inherently designed to be overbroad in the scope of people that it denies. So the United States, sort of by merit of geography, has the pick of whatever refugees we want by geography and economy and all the benefits of living in the United States. So the United States, in its refugee vetting process, we have clients who have applied for family members, which is really the only part of the process when the vetting occurs that we see when we do the family reunification part of the process. We have clients that have been denied for incredibly attenuated connections to banks that have once had dealings with a terrorist organization. So somebody's cousin, used to have an account at a bank that was implicated in something, and that person denied on security reasons. The appeals process is incredibly, not much information comes out of that appeals process, and the chances of winning on appeal are incredibly low. So people are vetted out of that process for incredibly minor details. The other thing is when you're squaring the stated reason of the administration to put in place extreme vetting procedures for the countries on the list as well as for refugees, if the reason that I find it difficult to square the idea that the reason for the period of 90 days is to put in place better vetting procedures when the argument for it is that these vetting procedures are impossible because we can't get the documentation necessary from these countries because they don't provide sufficient documentation. So I'm not exactly sure what their idea is on how they're going to create better vetting procedures than they already have. I don't know if you have any thoughts on that, but I'm
No, and I mentioned at the outset, this is a silly policy. It really is. I think one that has a rational basis, which is not a very high threshold, but it's not a very smart policy. The refugees have gone through insane amounts of vetting. It's quite extreme. The government's point, I think, is this, that often when documents are provided from these nations, we can't verify the documents are what they say they are. I think there are ways of addressing that sort of a complete and total shutdown on their entry. I don't know what that would be, but the means, are perhaps a bit too broad, but I do think it possesses a rational basis, especially because it's in the context of national security, affecting non-U.S. persons where there's not much of a vested right to begin with.
Maybe one more question.
Yeah, one more question.
One more question? One more. Come on, Duke.
Do you think it changes the metric at all if we interpret the travel ban as an Arab ban instead of as a Muslim ban?
You mean a nationality-based ban versus
Right,
a religious
nationality
ban?
or an ethnicity-based ban instead of a religious-based one. Do you think that changes the metric?
Is
at all?
Arab I don't know. You tell me. Is Arab a nationality?
I don't know.
I don't think it is.
Or ethnicity.
I mean, a Middle East ban, but that's not a
Well,
nationality.
there are countries included in the ban that are not Arab.
Somalia,
Predominantly Christian.
Yemen, right?
Even Afghanistan, if I'm not mistaken.
Yeah,
but
so I appreciate the difference between nationality and religion is very finite, but if it was if we said we have a policy, we're going to deny entry to people from Mexico, okay, then we have a nationality ban, and then you have, I think, maybe a different argument, but sorry, don't think so. Good thought, good try. A for effort. Anything else? Thank you all so much.
Yeah.
Thank you.